Now we consider intentional torts. Intentional torts are worth maybe half a dozen questions on the multi-state bar exam. This material is not the most important material, but it is some of the most straightforward material in torts. Remember, a plaintiff in a torts question is a civil litigant. He or she is going to want to be able to produce as many viable theories of liability as possible. As a candidate for admission to practicing law, you as a candidate are going to want to be able to identify and to distinguish between the various theories of liability. Intentional torts fall into two categories: intentional torts to the person and intentional torts to property. What you need to know is all of the different torts and the various elements of those different torts. Now, my approach to this material is about as straightforward and simple as you can get. I advocate that you memorize the most simple definitions, not the most elaborate ones. Get the basics down, the fundamentals down first. As you get into practice, you may choose to refine your definitions a little bit, and you certainly will be fleshing out a lot of the material that you don't know so well. So the purpose of this video is not to tell you everything you could conceivably need to know about intentional torts. The idea here is to identify what is present in the law and to give you a good framework for analysis. Remember, this material as a whole is only worth about half a dozen questions out of a 200-question multi-state bar exam. So there's no reason here to get caught up in the really tiny minutia, but at the same time, there's a body of knowledge here that you have to know completely. And that body of knowledge is, number one, what the various intentional torts are, and number two, what the basic elements of each of these theories of liabilities is. Now, before we can get to the various torts, we have to understand a little bit about intent. Since this material is about intentional torts, we have to focus on the mental state of the defendant a little bit. And this again is relevant not only for torts, but we'll be using the same basic frame of reference when we get to criminal law. Because in both of these areas, we have to establish elements of a theory of liability and then determine liability. In torts, it's civil liability. In criminal law, obviously it's criminal liability. So as we consider what is required for intent, obviously the defendant has to do something deliberately. So there has to be some volitional movement on the part of the defendant. He or she's got to do something. And beyond that, not only do they have to do it, but they have to intend to do it. So we'll see plenty of questions on the multi-state where a plaintiff, for example, is bumped into by a defendant who is pushed by some third party. Well, there's no intent on the part of the charged defendant, therefore no liability for the intentional tort of battery in that tiny little hypothetical. Now, with regard to intent in torts, keep in mind that there is specific intent, the strongest type of intent, the most deliberate action that can be taken by a defendant, then general intent, a somewhat more nebulous but still deliberate action by the defendant, and then finally, the idea of transferred intent. The defendant intends to strike A, but mistakenly strikes B instead. The intent to strike A is transferred to the plaintiff B, and the defendant is on the hook for liability based on establishing intent via transferred intent. So that's it. Those are the very basics on intent. As you go through practice, you may see that the examiners are testing fine points within that basic framework. At that point, go ahead and annotate your outline and make sure you understand the fine line distinction. But keep in mind, this is not the heart of the bar exam or even the heart of torts. Know it reasonably well. Be prepared to discuss it on an essay. Okay, that's it for the upfront considerations. Now let's get into the details of intentional torts. I've already indicated that the intentional torts fall into two broad categories: intentional torts to the person and intentional torts to property. As we consider intentional torts to the person, we see that these include assault, battery, and false imprisonment. And I think also we can acknowledge up front that there is something of a continuum between assault and battery. Certainly there is a distinction. They are not the same tort, but often they are connected, and a plaintiff that is able to establish a claim for battery often also can establish a claim for assault. And assault and battery do not necessarily merge into one theory of liability, and it is appropriate for us to consider them separately. So, what are the elements of assault? They're listed right in front of you on the outline, and there's not a whole lot of detail within assault. There's got to be an act, again by the defendant, that causes a reasonable apprehension of a battery on the part of the plaintiff. And that touching has got to be harmful or offensive. It does not necessarily have to be grievously injurious. A plaintiff can establish a battery claim just with an unpermitted touching, and we'll discuss whether or not any individual touching is harmful or offensive. And the plaintiff also has to show that the defendant intended the assault and that there was some causation between the defendant's actions and the plaintiff's perception. Now, there are a few little details about assault that are worth keeping in mind that go a little bit beyond the material that I've presented in the outline. First, the intent that is required here is the intent to cause an apprehension of an unpermitted contact. That's enough to satisfy the mental state of the defendant. Also, there has to be either actual contact or the intent of actual contact. Neither of these actually are required. Neither actual contact or intent of actual contact is required. Instead, what is required is the intent to cause an apprehension of such a contact. And keep in mind that there is a privilege to use assault or even reasonable battery to defend oneself, to defend others, and also to eject a trespasser. When we say colloquially, we're going to throw somebody out, that can actually involve physically tossing somebody off the premises if they are a trespasser. So there are defenses to assault that will be very much presented by the facts of various hypotheticals. And also keep in mind that the privileges that I've just referred to exist even if the person claiming the privilege is reasonably mistaken about whether or not the privilege would apply. So that's assault. Now we turn next to battery. Battery involves a harmful or offensive contact to the plaintiff's person, and again, the plaintiff has to establish intent and causation. This is very straightforward material, and you'll be surprised how frequently battery is tested, particularly on the multi-state. Remember that harmful or offensive contact does not require a physical injury. If we've got a situation where the defendant throws a snowball and knocks a hat off of the plaintiff without harming even the hat, maybe leaving a little bit of a wet mark on the hat, there's no real damage, but there has been a real battery, and the plaintiff can establish the claim and even seek punitive damages, despite the fact that the plaintiff was not physically injured. Also, as the hypo that I've indicated suggests, that damage or touching of the plaintiff's clothing or the plaintiff's car, if the plaintiff is driving a car, can be enough to satisfy the physical contact requirement. In other words, the defendant need not directly touch the person of the plaintiff. And that wraps up a very capsule summary of battery. But you'll see the essence is all there. And as you go into hypotheticals, you'll see this is material that is very difficult to test in a confusing manner. Next, the final intentional tort to the plaintiff's person is false imprisonment. False imprisonment consists of an act or an omission to act, a failure to act by the defendant that results in confining the plaintiff to some bounded area. And there'll be plenty of questions in various MBE practice that you do that will deal with what is a bounded area and what omission in particular is enough to satisfy the intent requirement for false imprisonment. Finally, the plaintiff has to show, again, intent and causation in order to establish a claim for false imprisonment. This is a fairly straightforward laundry list of elements, but false imprisonment actually can be a fairly technical and a fairly complicated subject, particularly on the MBE. Remember that the plaintiff need not physically resist being confined. We're not going to require the plaintiff to fight. The plaintiff will still be able to establish a claim for false imprisonment. Also, keep in mind that the imprisonment has got to be intentional, and it has to be without the consent of the plaintiff, areas that require fairly careful analysis of the facts in various hypotheticals. One of the most common defenses to false imprisonment is the shopkeeper's privilege. A shopkeeper has got a privilege to detain somebody that the shopkeeper reasonably suspects of shoplifting. And this is a sub-issue that has a fair amount of detail to it. It's best learned by doing practice. Next, the plaintiff has got to be aware of the confinement. We're not going to require the plaintiff to fight the confinement, but the plaintiff has to know about it. A plaintiff who doesn't know he or she has been confined has not been falsely imprisoned as far as the law of torts is concerned. Also, remember that any reasonable alternate route can defeat a false imprisonment claim. Just because a plaintiff is inconvenienced and has to change his or her direction of travel does not necessarily mean that there's been a false imprisonment. Now, if a plaintiff only would need to go through a door and instead has to go 10 miles, well, that's probably enough to establish a false imprisonment. But these are the sort of issues that come up with regard to what a bounded area is. And keep in mind also that only a wrongful arrest constitutes false imprisonment. Just because the plaintiff may be innocent of underlying criminal charges, the mere fact that the plaintiff is innocent of a crime does not mean that someone that confines that plaintiff, suspecting the plaintiff of being engaged in criminal activity, will be guilty of false imprisonment. If we mistakenly imprison someone, reasonably suspecting them of a crime, we're not going to be guilty of false imprisonment. I should say, we're not going to be liable for false imprisonment. And that wraps up the basics of the tort to the body of false imprisonment. Now, let's consider intentional infliction of emotional distress for a moment. IIED is also an intentional tort, although a little bit more intangible than an assault or a battery or false imprisonment. The elements of IIED include extreme or outrageous conduct by the defendant, not merely assaultful but outrageously assaulting behavior or other tortious conduct. There has to be intent to cause emotional distress or reckless disregard for the emotional well-being of the plaintiff. There has to be causation, and there has to be severe emotional distress. Now, one thing that you'll learn is that severe is defined fairly broadly, and we have many plaintiffs who are not really grievously damaged who are able to show severe emotional distress. Missing a night's sleep or two is probably good enough to establish severe emotional distress. Now, keep in mind that each one of these elements is subject to a fair amount of testing. But again, keep in mind there's only half a dozen MBE questions on this entire area of law, so it's unlikely that they're going to scrutinize your knowledge to a real fine point repeatedly. But still, it's worth knowing that the defendant's conduct, which we have to characterize as extreme and outrageous, has to strike a reasonable person as being extreme and outrageous. It would have to be substantially certain to cause severe emotional distress to any reasonable person. Next, also, where the defendant is aware of particular phobias or other weaknesses of the plaintiff, we are going to hold that defendant liable based on the defendant's knowledge. So if the defendant knows that the plaintiff, say, is phobic about dogs, that defendant is more likely to be responsible for IIED than someone who has no awareness at all of a plaintiff's particular emotional weakness. Now, if suppose we've got a bystander who watches a bad behavior on the part of the plaintiff. If that bystander is a close relative and has a special relationship with the victim, that bystander may have a valid claim for intentional infliction of emotional distress, a claim that will come with punitive damages if the plaintiff succeeds in establishing the theory of liability. And remember that extreme emotional distress does not necessarily mean a physical injury. Certainly, suppose we have a plaintiff who suffers a miscarriage as a result of the tortious conduct of the plaintiff. Well, that would almost certainly be enough to satisfy IIED. However, it's not required. A night's sleep or two missing can be good enough to establish a claim for IIED. And that wraps up a series of concerns about the theories of liability arising out of intentional torts to the person. In the next video, we will consider intentional torts to property and defenses to intentional torts.